Take your seat, please. I welcome you, and welcome also in particular representative for the respondent and representative for the applicant. Dr. Eno, please, you have the floor.
Thank you, President. Honorable President, honorable judges, this is a public hearing in the matter of Robert John Penessis versus the United Republic of Tanzania, registered as application 013 of 2015. Honorable President, both parties were duly informed of this hearing and are duly represented in court today. Thank you, Honorable President.
Thank you. Representative of the applicant, you have the floor to present the case. You have 45 minutes. 45 minutes.
May it please you, Honorable President of the Court and Honorable Justice of the Court. My names are Penessis representing the applicant in this matter. Honorable Justices, pursuant to the leave of the court granted under Rule 50 of the Rules of the African Court on Human and People Rights, the applicant hereby submit his argument and evidences on merit of the above referred cases. Before we submit, we also would like to pray before this honorable court to adopt the reply that the applicant did against the respondent and all paragraphs therein. Structures of our submission. The present merit submission are broken into 5 separate sections. Section 1 provides for summary of facts of the above referred case. Section 2 confers for the admissibilities. Section 3 covers for the nationality of the applicant, while Section 4 explains in detail the alleged human rights violation under Article 1 and Article 12, Sub 1 and Sub 2 of the African Court's Charter on Human and People Rights. And finally, in our submissions are prayers before this Honorable Court. Summary of facts. Thus, one Robert John Penessis, a Tanzanian citizen, was unlawfully arrested when entered at Kiaka border on 8th day of January 2010 with a Tanzanian emergency travel document number 0513590 issued at Muleba, Kagera, and it was entered into the immigration registry book as he entered into Tanzania. As a result of his unlawful arrest, he was charged with 2 counts, being unlawful entering and in premises in Tanzania, and he was charged in a criminal case number 35 of 2010 at Kagera Residence Magistrate on 17th day of January 2010, and he was convicted on both counts and sentenced to pay a fine of 8,000 Tanzanian shillings or to 2 jails term in default of payment of fine, and also it was ordered that he suffered 10 stroke of cane. So it took only hardly 9 days, the fastest case ever in Tanzania, for the applicant to be convicted. The applicant being satisfied with the judgment, he appealed to the High Court of Tanzania at Bukoba in criminal appeal number 9 of 2011. The court on 6th day of June 2011 upheld the conviction but set aside the sentence of corporal punishment. Being aggrieved by the decision of the High Court, he appealed to the Court of Appeal of the United Republic of Tanzania at Mwanza in criminal appeal number 179 of 2011. The Court of Appeal of Tanzania on the 4th day of June 2012, it upheld the conviction, though held that the court was not the proper body to issue the deportation order, rather that it is the jurisdiction of the responsible minister, being the Minister of Home Affairs. Honorable Justices, that after all the applicant appeals were held against him and his constitutional right, and yet the applicant supposedly to have completed his 2 years in 2012. His 20 years, that was legal sentence, but he was still held against his constitutional right at Bukoba Central Prison, to date. And that is contravened the African Charter on Human and People Rights, particularly Article 12, Sub 1 and Sub 2 of the Charter. That after the expiration of 2 years, where the applicant was sentenced by the court, the effort were done by his parents and relatives to ensure that the applicant is released from the detention facilities. But the effort did not bear any fruit. Hence, the applicant decided to file an application before this honorable court on 2nd day of June 2015 through his grandmother and against the United Republic of Tanzania for unlawful detention. Honorable President and Honorable Justices of the Court, now we turn to Section 2, admissibility. Honorable Justices, in the applicant's submission that Article 6 of the Protocol and Rule 40, Sub-Rule 1 up to Sub-Rule 6 of the Rule of the Court set out conditions that must be met before an application can be considered by the court, by this court. The condition inter provide pursuant to the provision of Article 56 of the Charter, to which Article 6, Sub 2 of the Protocol refer. Application to the court shall comply with the following condition. 1, disclose the identity of the applicant, notwithstanding the letter request for anonymity. 2, comply with the Constitutive Act of the Union and the Charter. 3, not contain any disparaging or insulting language. 4, not based exclusively on news disseminated through the mass media. 5, be filed after exhausting local remedies, if any, unless it is obvious that this procedure is unduly prolonged. 6, be filed within a reasonable time from the date local remedies were exhausted, or from the date set by the court as being the commencement of the time limit within which it shall be seized with the matter. 7, not raise any matter or issues previously settled by the parties in accordance with the principle of Charter of the United Nations, the Constitutive Act of the African Union, the provision of the Charter, or of any legal instrument of the African Union. On condition 1, 2, 3, 4, and 7, the applicant generally submit that the claim is compatible with the provision of the Constitutive Act of the African Union, that the claim is not exclusively based on information circulated by the media, and that the same issue has not been considered according to another international jurisdiction or procedure. On condition 5 and 6, Honorable Justices, the applicant submit that, first, a number of efforts have been done to exhaust all the available remedies. A local remedies has been defined as any legal action that may lead to the resolution of the complaint at a local or international level. And that was held in a constitutional right project, CRP versus Nigeria, communication number 60 of 1991. In the words of the African Commission, exhaustion of the local remedies is intended to give domestic courts an opportunity to decide upon cases before they are brought to an international forum, thus avoiding contradiction, judgment of law at a national and international level. And that was confirmed in the case of Sirac versus Nigeria, communication number 155 of 1996 at paragraph 37, Honorable Justices. That being the case, it is established in international human rights law that only domestic remedies that are available, effective and adequate, sufficient, that need to be exhausted. As it was held in the case of Institute of Human Rights and Development in Africa and Open Society Justice Initiative on behalf of children of Nubia descent in Kenya versus the government of Kenya, decision number 002/COM/22/002 of 2009. And also the same was held in the case of Jawara versus Gambia, the case of year 2000, Honorable Justices, reported at AHRLR at page 107. In communication number 147 of 1995 and communication 149 of 1996, the African Commission held that a remedy is considered available if the complainant can pursue it without impediment. It is deemed effective if its offer prospect of success, and it is found sufficient if it is capable of redressing the complaint. It is followed, therefore, that the local remedy rule is not rigid. With this position, Honorable Justices, and with regard to the history that no appeal has ever succeeded on favor of the applicant in the United Republic of Tanzania, then the applicant had exhausted all local remedies available. Therefore, this Honorable Court is the only remedy that remain for the applicant. In his home country of the applicant, the local remedies were unavailable, ineffective, and inadequate. Thus, the applicant filed before this honorable court should be admissible, and it is the only remedy available. Honorable President and honorable justices of the court, the applicant contends that there has not been any undue delay. This is due to the fact that after the Court of Appeal decision, the applicant made follow-up to the government and was granted several appointments thereto, but the matter was not resolved. Hence, that's what made the applicant to come before this honorable court to seek justice. Honorable President and honorable justices of the court, I would like to refer also this court to the case of Dr. Farouk Mohammed Ibrahim versus Sudan, a communication number 386 of 2010 at paragraph 71 and paragraph 72. The commission had this to say in this matter, that reasonable time before the commission proceed to analyze whether the communication was submitted within a reasonable period of time. It is important to underline the fact that reasonable time does not pertain in the period when the alleged allegations were committed as submitted by the respondent state. End of quote. It is computed from the time when the communication was submitted to the commission after exhaustion of local remedies, or when complainant immediately realized that the local remedies are not available, sufficient, or effective. Honorable Presidents and honorable justices of the court, what was held by the commissions is opposed to inter-American and European human rights systems, which prescribes 6 months as a reasonable time period. So in inter-American and Europeans, they have a limitation of time. The African Charter does not have provision or definition with respect to reasonable time. Reasonable time. In the absence of this, the Commission has been flexible, treating each case based on context, characteristic, ascension, and the notion of reasonable time before within the Commission depend on circumstances of every case. Honorable Justices, we now turn to Section 3, the nationality of the applicant. It is the applicant's submissions, Honorable Justices of the Court, that one can acquire citizenship in Tanzania either by birth or naturalization as per the Tanzanian Citizenship Act, Cap 357, revised edition of 2002. According to the provision of Section 3, subsection 1 of the Tanzania Citizenship Act, a citizen by birth is defined to mean a person who is a citizen of the United Republic in the following context. By virtue of the operation of Section 4, which provides for a person having born in mainland Tanzania or Zanzibar before the Union Day. By virtue of Section 5, which provides for a person born in the United Republic on or after the Union Day. By virtue of his birth in Zanzibar and the effect of subsection 2 of Section 4. From the above analysis, Honorable Justices of the Court, it is quite clear that the applicant who has with him a birth certificate showing that he was actually born in Tanzania in the year 1968, the year after the Union Day. Then, in that context, the applicant is a legitimate Tanzanian citizen by virtue of his birth. Honorable Justices, the applicant further submits that he has never renounced his citizenship or being deprived the same by the minister in Tanzania. According to the provision of Section 13, subsection 1 of the Tanzanian Citizenship Act, Cap 357, it provides as follows. If any citizen of the United Republic of full age and capacity make a declaration in the prescribed manner, renounce his citizenship of the United Republic, the minister may cause the declaration to be registered, and upon that registration, the person in question shall cease to be a citizen of the United Republic of Tanzania. The applicant, Honorable Justices, has never, ever applied such a application as to renounce his citizenship. Also, under a provision of Section 14 of the Tanzania Citizenship Act, it also provides as follows. The minister may by order deprive any person other than a person who is a citizen by birth of his citizenship of the United Republic if the minister is satisfied that that person has at any time while a citizen of the United Republic and of a full age and capacity voluntarily claimed and exercised in a foreign country and in right available to him under the law of that country, being a right accorded exclusively to its own citizen, and that it's not conducive to the public good that he should continue to be a citizen of the United Republic of Tanzania. Honorable Justices, the minister responsible has never deprived the applicant his right according to the section cited above. He was detained illegally. There is no any procedure, and the applicant has never been enjoying any other privilege or in any other country, and he has never been a rebel. He has never been against the United Republic of Tanzania as by the virtue of this section. Therefore, from the wording of the above provision, the applicant has never made any declaration, denounced his citizenship, and on the power of the minister deprived a person, he has never been deprived by the minister. Therefore, being in detention in Bukoba prison to date is illegal. Honorable Justices, we now turn to Section 4, the merits of this application. Article 1 of the Charter provides that the member state of the Organization of African Unit, parties to the present Charter, shall recognize the right, duty, and freedom enshrined in this charter, and shall undertake to adopt legislative or other measure to give effect to them. While the court has not previously had the opportunity to adjudicate on this article, it has come before the African Commission on a numerous occasion. Essentially, Article 1 gives the Charter the legal binding character always attribute to international treaty of this sort. Therefore, a violation of any provisions of the Charter automatically means a violation of Article 1. If a state party to the Charter fails to recognize the provision of the same, there is no doubt that it is in violation of the article. Its violation, therefore, goes to the root of the Charter, as it was provided in the case of David Jawara versus Gambia in the year 2000 AHRLR at page 107. That is in communication number 147 of 1995, was quoted from there. Honorable Justices, the proprietary nature of Article 1 has meant that at a time the African Commission has found a violation of Article 1, even though the claimant, him or herself, has not pleaded that particular article. For example, in the case of Kevin Mugwanga Guname et al., excuse me, maybe it is more French, and I'm not very good in French, versus Cameroon, the Commission stated that according to its well-established jurisprudence, the African Commission holds that a violation of any other provision of the African Charter automatically constitutes a violation of Article 1, as it depicts a failure of the state party concerned to adopt adequate measure to give effort to the provision of the African Charter. Thus, having found violation of several provisions in the above analysis, the African Commission also find the respondent state violate Article 1. The court is respectfully invited to follow the approach adopted by the Commission in respect of Article 1, according with the court find violation of article pleaded below. It is followed that the respondent state is in violation of Article 1. Therefore, the United Republic of Tanzania, which is party to the article, is also violation of Article 1 by detaining its own citizen and try to deport to a unknown country. Honorable Justices, violation of Article 12 and Article 12.1 and sub 2, right to freedom of movement. Article 12, sub 1 and 2 of the Charter provides as follows. Every individual shall have the right to freedom of movement and residence within the borders of a state, provided he abides by the law. Every individual shall have the right to leave any country, include his own, and return to his country. This right may only be subject to restrictions provided by the law for the protection of national security, law and order, public and health. Article 12, sub 1 and sub 2 Honorable Justices accords every individual in a member state the right to freedom of movement and residence and the right to live and to leave his country and return to it with possible restriction for protection of national security. The applicant has not threatened the peaceful or breached any of the above cited section of the article. Once we, Honorable Justices, let me also remind the Honorable Court the case of Recompte, Africain, you'll also excuse my French, pour la défense des droits de l'homme versus Zambia. Communication number 71 of 1992 at paragraph 22. In this case, it involved about 517 West African immigrants. And the involving explosion of about 517 West African immigrants by the government of Zambia by the ground of residing in Zambia illegally. The Commission stressed that Article 12 imposed an obligation on the contracting state to secure the rights protected in the Charter to all persons within their jurisdiction, national and non-national. Honorable Justices, so you can see that the law, not only that it protected the citizens of a certain state, but also those who are non-citizens of that country, as provided in the Zambia case. The applicant being a citizen of United Republic of Tanzania by birth, he has the right to enjoy the freedom of movement, to live and return to his country. Even the Tanzanian constitution is amended from time to time, borrow almost a similar provision as that of the Charter, and provide as follow. Article 17, Article 17, sub-article 1 of the Constitution of the United Republic of Tanzania 1977 is amended, provide as follow. Every citizen of the United Republic has the right to freedom of movement in the United Republic and the right to live and in part of the United Republic, to live and to enter the country, and the right not to be forced to leave or to be expelled from the United Republic of Tanzania. So the applicants, being a citizen of the United Republic of Tanzania, had to enjoy the aforementioned rights and not being unlawfully arrested and detained. It is very strange that the respondents are claiming that the birth certificate of the applicant with registration number 0001642 is a forged. And they assent that they have never charged him. In their reply, they conceded that they have never charged him for a forgery document. Honorable Justices, forgery is a criminal offense in the United Republic of Tanzania, and under Section 337 of the Tanzania Penal Code provide that any person who forge any document commit an offense and is liable unless owing to the circumstances of the forgery or the nature of the thing forged, some other punishment is provided to imprisonment for 7 years. So it is so strange that the respondents are claiming that the birth certificate is forged, but they did never move on to charge the applicant with the forged certificate. Because of the time. Honorable President and Honorable Justices, therefore, under the basis of our submission up here in above, the applicant wished to conclude that the right to freedom of movement is a fundamental human right recognized in international human rights instruments such as UDHR, ICCPR, and other regional human rights instruments. The right to freedom of movement is not only to move within the country, but also it is protection from forced eviction or displacement. The Tanzanian government had a primary responsibility to respect, protect, and promote the right to freedom of movement. By not doing so, the respondent had violated these rights by unlawfully arresting and detaining the applicant when he was entering the country. And not only that, Honorable Justices, if he was sentenced for 2 years in 2010, then his 2 years must have ended in 2012, but to date is still in detention, unlawfully without any court order. Honorable President and Honorable Justices, we now turn to Section 5, which is our prayers for our submission. That is, in view of the foregoing submission, the applicant humbly prays the court to make the following orders. 1, declaration that the court has jurisdiction to entertain this claim and that it is thereby admissible. 2, that Mr. Penessis, Robert Penessis, is a citizen of the United Republic of Tanzania. 3, a declaration that the United Republic of Tanzania has violated the right to freedom of movement under Article 12, Sub-Article 2, and Sub-Article 1, and Sub-Article 2 of the African Charter. 4, order the respondent, this honorable court, we pray that to order the respondent to release the applicant from an illegal detention forthwith. We humbly and respectfully submit.
You still have 5 minutes. Are you done with your submissions?
Yes, Honorable President, maybe I may pray to the court that my 5 minutes should be also reserved for later on in any.
Okay.
Yeah.
Okay. Thank you very much. Representative of the state, of the respondent, it's now your turn to present your submissions. You also have 45 minutes from now.
Thank you, Honorable Judge. My name is Sarah Mwepopo. I'll be representing the respondent state in this application, and I will be assisted by the following officers. Nkasori Sarakikia, who is also a principal state attorney like me. Hashim Gole, senior state attorney. Richard Kilanga, senior state attorney. Lenatus V. Mwambene, immigration officer from the immigration headquarters. And lastly, we still have Henry Shuza Bitigeko, who is an administrative officer from the Registration Insolvency Trusteeship Agency, Dar es Salaam, which is also acronymed RITA. And lastly, Blandina Kasagama, who is a legal officer from the Ministry of Foreign Affairs and East African Cooperation. Honorable judges, let me now move to the first round of our oral submissions. We also pray that our written submissions which were filed in court be adopted as part of these submissions that we are making today. Without further ado, let me just proceed to submit on our first round of oral submissions. Honorable judges, the applicant in this matter, Robert John Penessis, is also known as Robert John Maitland, and also known as Robert John Rubinstein. He is currently at Bukoba Central Prison, where he is awaiting deportation to South Africa, as he was found guilty of the offense of unlawful entry and presence in the United Republic of Tanzania, contrary to Section 31(1), Roman 1, and subsection 2 of the Immigration Act, Cap 54 of the revised edition of the laws of Tanzania of 2002. Honorable judges, it was while efforts were ongoing to deport the applicant to his home country, South Africa, that application number 013 of 2015 was initiated by a letter to the Honorable Court by one Georgia Penessis on behalf of the applicant. A woman allegedly residing in Greece and claiming to be the 90-year-old grandmother of, okay, thank you. Let me just go again. It was while efforts were ongoing to deport the applicant to his home country, South Africa, that application number 013 of 2015 was initiated by a letter to the Honorable Court by one Georgia Penessis on behalf of the applicant, a woman allegedly residing in Greece and claiming to be the 90-year-old grandmother of one Robert John Penessis, who is now the applicant in this matter. In her letter to the Honorable Court, she stated that Robert John Penessis is a Tanzanian by birth, as she herself is from the Muhaya tribe of Tanzania, and that her grandmother was from the Sukuma tribe, and that all her family members, including Robert John Penessis, are Tanzanians by birth. Therefore, the detention of the applicant is unlawful and a violation of the applicant's human rights. Further, that the applicant is rendered stateless and in violation of the Geneva Convention, she said Geneva Convention Protocol 1 up to 4 of 1947, whereby Section 59(1) states that detention is not to exceed a period of 6 months, upon which a person is to be declared a refugee and submitted to the Red Cross or be deported within 14 days. She concluded her letter dated 10th May 2015 by asking what procedure should be followed to have the applicant released and whether her family should lodge a case against the state. Honorable judges, the respondent strenuously denied all the allegations raised in the reply to the letter by Georgia Penessis, including those, the respondent denied all the allegations, including those related to the violation of the Geneva Conventions, which are irrelevant in the circumstances of this case, and they would only apply in wartime and not during peacetime. Honorable judges, in order to make clear the circumstances of the application, of the applicant's detention, the respondent wishes to pray, the respondent prays to provide the background of the matter. Honorable judges, according to the official records available, in June 2008, one Robert John Rubinstein approached the immigration office at Kagera Regional Immigration Office, Bukoba, to apply for a residence permit. The documents he produced to support his application for a residence permit were a certified copy of his British passport with number 730124818 and a supporting affidavit. The passport, now I'm talking about a copy of the certified copy of the British passport. The passport is from the United Kingdom of Great Britain and Northern Ireland, bearing his name as Robert John Rubinstein and reflecting his nationality as a British citizen issued at the British Embassy in Athens. It also reflects that his place of birth is Johannesburg and his date of birth is 25th September 1968, valid from 19th September 2001 to 13th April 2010, and it's actually mentioned in the judgments of the national courts which decided on this matter, which judgments were also filed as part of our written submissions filed to the court earlier on. Regarding the supporting affidavit, which he used in support of his residence permit application, the supporting affidavit reflected his place of birth in Tanzania at Buguma Estate, Ihangiro, Rihija, Muleba district in Kagera region, contrary to his British passport now, which reflects that his place of birth is Johannesburg. Now we have his supporting affidavit reflecting his place of birth being Ihangiro, Rihija, Muleba district in Kagera region. His date of birth, again, is the same, 25th September 1968. He swore under oath that his real father is Kenneth Maitland John, that his mother was Mary Penessis. He stated further that his guardian who raised him after his mother died is his mother's sister, one Anastasia Penessis. These contradictions over his place of birth, his mother's name, and his father's name gave cause for the immigration officers to investigate Robert John Rubinstein. Investigation by the immigration officers revealed that Robert John Rubinstein also possessed a South African passport reflecting his nationality as South African, his place of birth as South Africa, and his date of birth, again, 25th September 1968, issued by the Department of Home Affairs in South Africa and valid from 8th September 1999 to 7th September 2009. This is also contained in the judgments of the national courts, which were filed as part of our written submissions in court. All this led the government to start liaising with the South African authorities in Greece, who reported that one Robert John Maitland, born in South Africa on the 25th September 1968, changed his name in the registers of South Africa to Robert John Rubinstein. Again, a copy of the certificate verifying a change of these names was also filed as part of our written submissions filed in court. Based on the strength of his South African passport, which expired on the based on the strength of his South African passport, which expired on the 7th of September 2009, compounded by the fact that he never completed his application for a residence permit, he was arrested and charged with the offense of unlawfully entering and presence in Tanzania, contrary to Section 31, subsection 1, Roman 1, and of course subsection 2 of the Immigration Act, Cap 54 of the revised edition of the laws of Tanzania of 2002, in criminal case number 35 of 2010 at Kagera Resident Magistrates Court in Bukoba. On the 24th of February 2010, the case which came to be entitled or known as the Republic versus John Robert Penessis, alias Robert John Maitland, alias Robert John Rubinstein. Honorable judges, the applicant's defense was that he is a Tanzanian by birth and therefore he didn't require a residence permit to reside in the country and is therefore not guilty of the charges against him. However, during the course of the trial, it was proven that the applicant possessed dual citizenship of the United Kingdom and South Africa, with both passports reflecting he was born in South Africa. He was convicted on both counts on 17th January 2010 and sentenced to pay a fine of 80,000 Tanzanian shillings or 2 years jail term in default of payment of fine. The court also ordered that he suffer 10 strokes of the cane. He appealed to the High Court of Tanzania. He appealed to the High Court of Tanzania at Bukoba in Criminal Appeal number 9 of 2011 as John Robert Maitland. And during the hearing of the matter, the Honorable Judge allowed the appellant to produce additional documents to support his claims. However, upon submission of an emergency travel document, which the Republic questioned, the appellant tore the document in court. As a result, he was found in contempt of the Honorable Court and sentenced to 6-month imprisonment. The appeal commenced on the 6th day of June 2011. The High Court upheld the conviction of unlawful entry and presence in the country, but set aside the sentence of corporal punishment and ordered that upon the completion of his sentence for contempt of court, he should be immediately deported to his home country, South Africa. The applicant further appealed to the Court of Appeal of Tanzania in Mwanza, Vide Criminal Appeal number 179 of 2011 as John Robert Maitland against the High Court decision to uphold his conviction of unlawful entry and presence. Again, the Court of Appeal of Tanzania on the 4th day of June 2012 delivered its judgment whereby it upheld the conviction, though held that the court was not the proper body to issue the deportation order. Rather, it is the jurisdiction of the responsible Minister of Home Affairs. However, with regard to the contempt of court charge, the Court of Appeal nullified the proceedings and the sentence emanating from it was set aside. Thereafter, the Minister for Home Affairs issued a deportation order and a detention order against Robert John Rubinstein as per the Immigration Act. He was taken to South African Embassy in Dar es Salaam to process his travel documents for his deportation. However, he refused to cooperate with the immigration officers and refused to meet with the South African officials for purposes of having his fingerprint impressions collected. The applicant was thereafter taken to Bukoba Central Prison, pending his deportation with the immigration officers, following up with the necessary arrangements. The government of South Africa was prepared to receive the applicant on the condition that his fingerprints be taken in compliance with their procedure. However, on several occasions when the South African officials visited him at Bukoba Central Prison, and also when immigration officers from the headquarters in Dar es Salaam went to take the applicant's fingerprint impressions and collect his original passport on 9th August 2013, he again refused to have his fingerprints taken to facilitate his deportation. The applicant was advised by the immigration officers that when he was ready to cooperate, to duly contact the immigration officers through the prison authorities in order to facilitate his deportation. The applicant, it is on record that the applicant eventually agreed to have his fingerprints taken, but again refused to be taken to South African Embassy for further processes. It should also be noted that over this period of time, instituted various criminal applications for habeas corpus against the Minister of Home Affairs, the Commissioner for Prisons, and the Attorney General, being miscellaneous criminal applications number 1 of 2013, number 1 of 2014, and number 24 of 2014 at the High Court at the High Court of Tanzania in Bukoba. He also filed an application for habeas corpus at the High Court of Tanzania at Dar es Salaam in miscellaneous criminal application number 133 of 2014. We wish also to update this court that the applicant has also filed another application since 2016, which is civil application number 32 of 2016 before the High Court of Tanzania at Bukoba, whereby he is seeking declarations from the court to be declared as a citizen. So as we are submitting today, we should be aware of the fact that there is this other pending case before the High Court of Tanzania in Bukoba, also asking for the same remedy to be declared a citizen of Tanzania. It's a case of 2016, and we kindly ask the court to take note of this fact. That during the investigation for the miscellaneous criminal application for habeas corpus filed at the High Court in Dar es Salaam, it was further discovered that the Tanzanian birth certificate with number 0001642 provided by Mr. Penessis was forged as verified by the Registration and Insolvency Trust Association, RITA. This is a fact that will be expounded later in our second part of the submissions. But at this point, we would like to note that criminal charges or offenses in Tanzania have no limit. They have no time limitation. But also, since it is also a forged document, it doesn't even exist in the register of the registrar of birth and death. So that's the effect. It doesn't even exist in the registers. But this will further be expounded later on. Honorable judges, may I move on with my submissions? The applicant, Robert John Maitland, alias Robert John Rubinstein, and alias Robert John Penessis, is currently at Bukoba Central Prison under a lawful detention and deportation order issued by the Minister of Home Affairs. Is not facing any criminal or civil charges, is still at Bukoba Central Prison as the respondent state is awaiting for his deportation, for him to comply with the requirements of his deportation to South Africa. And he's also still in detention because he was still pursuing his cases within the justice system. So that's why that's another reason as to why he's still in the detention. Further, he had indicated that he may wish to appeal against the High Court decisions in his various applications of habeas corpus within the respondent state. And also this raises the issue of the exhaustion of local remedies. It is for these reasons that the respondent will argue in the second part of our submissions that the applicant is not a citizen of Tanzania, in that his detention is lawful and caused by his lack of cooperation, as he refuses to work with the authorities to process his deportation to his home country. Honorable judges, before we expound on the issues of merit, the respondent would like to quickly reiterate on the preliminary points of objection raised by the respondent on issues of jurisdiction and admissibility of the application. And with your leave, honorable judges, may I submit quickly on the issue of jurisdiction. The jurisdiction of this court is provided under Article 3 of the Protocol to the African Charter on Human and People's Rights, but also this provision is also reiterated in the rules of the court, whereby the court is granted whereby these provisions provide that the jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation and application of the Charter, this protocol, and any other relevant human rights instrument ratified by the state concerned. It is our argument that what has been submitted by the applicant is not an application as envisaged by the protocol to the African Charter on the establishment of the court. Rather, the application is a letter from Georgia Penessis to the Honorable Court seeking direction in the way forward with regard to addressing her grievances. She closes her letter as follows. and I quote, "We would appreciate your help and advice, what procedure we should follow to have him released based on people and African rights, and if my family should lodge a case vesting the state. I look forward to your reply," end of quote. So this is a quotation from the letter that was filed by Georgia Penessis before this court. It wasn't an application. We would like this court to note that it wasn't an application within the meaning of the rules and the provisions governing the procedure to be followed when filing applications before this court. It is not known whether the Honorable Court responded to the letter with further directions as requested on whether she should indeed sue the government of Tanzania or not. She should indeed sue the government of Tanzania or not. The respondent reiterates that the applicant was merely seeking direction from the Honorable Court. She had not yet indicated whether she had decided to indeed pursue her grievances at the African Court. Whether she has decided to indeed pursue her grievances before the African Court. So what we are reiterating under this part is that it was not an application envisaged by the court, because it was just a mere letter, and it's in total violation of the rules of the court. And another argument to dispute the jurisdiction of the court is on the issues of evidence. The applicant is actually requesting this court to rule on evidential issues which have been closed before the National Court of the Respondent States. And this court said so in the case of Ernest Mtingwi, that it will never indulge on issues of evidence, but also on the issue of jurisdiction. The applicant cited the Geneva Conventions of 1949. We argue that those are not human rights instruments and they apply in wartime. They are humanitarian instruments applying during wartime and not during peacetime. So in view of those arguments, we pray that this court has no jurisdiction to entertain this case. On the issues of admissibility, we have taken issues on Rule 40, sub 5, where we emphasize that the applicant has not exhausted local remedies before the national courts, because he still has so many remedies to exhaust. He hasn't even administratively challenged the deportation order, the deportation and detention order by the minister. This remedy is still available. He only applied for habeas corpus applications, but also again, these applications were withdrawn and also struck out and dismissed by the court, but he has never reinstated them. He has never appealed against those habeas corpus applications. And as I said earlier on, he's still having another application to be which is yet to be determined by the court. So the issue of exhaustion of local remedies is yet to be concluded on the applicant's side. We cited the case of Saringon in our submission to support this, but also some cases have been cited this morning by the counsel for the applicant. The CRB, the CIRAC case all support our contention, but also the case of Dauda Jawara is a testament to the fact that there are indeed available remedies in Tanzania and they should be pursued by the respondent. On the case of Rule 40 sub 6, we still emphasize that the reasonable criteria hasn't been adhered to by the applicant when it comes to filing these cases after your last remedy has been concluded. The application to determine his citizenship was concluded in 2012, and he filed this application before this court in 2015, 3 years after the application. And contrary to what has been said this morning by the counsel for the advocate that the African system has not set the time limit, that's not true, because through the case of Majuro versus Zimbabwe, the time limit has been set to 6 months, and this applicant is clearly out of 6 months. 3 years is beyond 6 months, stipulated by the African Commission, which is a sister body or sister institution to the African Court. There are also some of the applications which are yet to even be pursued for purposes of appeal and for purposes of being reinstated. And for those, we state that it is still very premature to come before this court to file an application before the African court. On these issues, let me just end up here for these preliminary issues and invite my colleague to argue on issues of nationality and, of course, the issue of the detention order by the issue of the detention order given by the Minister for Immigration Affairs. Thank you, Honorable Judges. I submit for your judicial consideration.
Is resolving the problem. S'il vous plaît, dans la cabine, pouvez-vous essayer l'interprétation? Oui. Oui, ça va. Juge Rafa.
En fait, c'est qu'on entend toutes les langues.
Ok, please. Ok. Bon, je pense que... ok. I think we should continue. And while they are solving the problem. Okay, we have interrupted you, but you still have your 45 minutes. So we have just suspended the time now, okay? Please proceed.
Thank you, Mr. President. Thank you, Mr. President, honorable judges. As we proceed to counter the allegations on merit against the respondent state, it is recalled that the initial allegations against the respondent state were as follows: that the applicant has been illegally imprisoned in Bukoba prison since 7th January 2013 on the ground that he did not use a visa to enter the respondent state, that the applicant's imprisonment is an illegal detention and against people's and human rights, that the applicant has not committed a serious offense like murder, that the applicant's detention document did not bear the official stamp hence he's being unlawfully detained, that his detention is aimed at alienating his properties, that his health has been deteriorating since he was imprisoned, and he has acquired recurring chronic malaria and lung disease, that his relatives and lawyers were not permitted to visit him, that he's being considered a stateless person while he's a Tanzanian by birth and descent. All these allegations were countered by the respondent in its reply to the letter written on behalf of the applicant, although we did join hands with the issue that he has not committed a serious offense like murder. The Honorable Court, in its wisdom, has directed that submissions now during the public hearing be based on two issues. Firstly, the nationality of the applicant, whether he is or not a Tanzanian, and secondly, the alleged unlawful arrest and detention of the applicant. Honorable judges, I pray to proceed with submitting on the first issue on the nationality of the applicant. Honorable judges, under the Tanzanian Citizenship Act, Cap 357, citizenship is attained or acquired through three means: by birth, by descent, and by naturalization. The allegations raised by the applicant are that he's a Tanzanian by birth. Honorable judges, as we ascertain the nationality of the applicant, there are three principles which have to be considered in the United Republic of Tanzania. Firstly, the terms nationality and citizenship are used interchangeably in the respondent state. Both are controlled by one's place of birth, which is prima facie evidence of one's nationality and citizenship. Although specific issues of birth are guided by the Birth and Deaths Act, and specific issues of citizenship are guided by the Citizenship Act. This position was cemented by the Court of Appeal of Tanzania in the case of Attorney General and others versus Kaburu, found in the Tanzania Law Reports, where at page 194 the Court of Appeal held, "We are satisfied that the term nationality, as used for purposes of registration of births under the Births and Deaths Registration Ordinance, connotes citizenship." A second factor to consider is that in the United Republic of Tanzania, the burden of proof as to one's nationality, one's citizenship, lies on the party claiming to be a Tanzanian. Section 30 of the Citizenship Act provides that where in any proceedings under or for any purposes of this Act, any of the following questions is an issue, namely, whether any person is or is not a citizen of Tanzania, and whether their presence in Tanzania is unlawful. The section stipulates that the burden to prove that person is a citizen of Tanzania or that his presence in Tanzania is lawful shall lie upon the party contending that the person is a citizen of Tanzania, or as the case may be, that his presence is lawful. This was also cemented in the aforementioned case, Attorney General and others versus Kaburu, where the Court of Appeal held at page 194 that we are satisfied, according to the law of this country, that the third appellant must be regarded as having acquired the nationality or citizenship of both his parents at the time he was born, and that such naturalization continued until the time when, under Tanzanian law, he was required to choose between Tanzania citizenship or Indian citizenship, unless such presumption is rebutted by credible evidence. In our considered opinion, the burden of rebutting such a presupposition is with the person who seeks to rebut it. Therefore, in Tanzania, the law is quite clear that the onus, the burden, rests on the person claiming to be a citizen. A final yet pertinent point to consider is that there is no dual citizenship in the United Republic of Tanzania. Section 74A of the Citizenship Act provides as follows: a citizen in the United Republic shall cease to be a citizen if, having obtained the age of 18, he acquires the citizenship of some other country other than the United Republic by voluntary act other than marriage. It is against these principles that the applicant's nationality, based on his birth, can be ascertained. It stands to reason that in order to ascertain his nationality or citizenship by birth, then his place of birth is a crucial factor. In this regard, it is recalled that during the applicant's trial in criminal case number 35 of 2010, the prosecution submitted certified copies of the applicant's passports from the United Kingdom and from the Republic of South Africa. These have been referred to during the preliminary submissions. The passport from the United Kingdom clearly bore his name, Robert John Rubenstein, stating he's a British citizen and his place of birth is Johannesburg, South Africa, born on 25th September 1968. The passport was issued at the British Embassy in Athens, Greece. The passport from the Republic of South Africa, it was a certified copy, was issued by the Department of Home Affairs in South Africa, reflecting his nationality as South African and his place of birth as South Africa. His name reflected Robert John Rubenstein. It is recalled that these passport copies were attached by the applicant himself in his application for a Tanzanian residence permit. This begs the question, why would a Tanzanian need a residence permit to reside in Tanzania? A Tanzanian does not require residence permits. Therefore, the applicant is not a Tanzanian. The applicant is a South African national born in South Africa, as reflected in both his British and South African passports. Honorable judges, this was duly upheld by the trial court, the resident magistrates court at Bukoba in the original criminal case. At page 9 of its judgment, the court stated, the question comes that if the accused person is a citizen of the United Republic of Tanzania, why then was he making an application for a resident permit? It is issued to a person of another country to permit him to live or reside in Tanzania for a specific period of time and for specific activities. Therefore, the accused person is not a Tanzanian. This was duly held by the trial court. The High Court shared similar sentiments. At page 24, 25 of its judgment, the High Court judge stated, I therefore come to the conclusion that the appellant is not and has never been a citizen of the United Republic of Tanzania, and his presence in the country is unlawful as charged. This was also upheld by the Court of Appeal of Tanzania. Page 7 to 8 of its judgment, the Court of Appeal stated, there is on record undisputed evidence showing that the appellant is a British citizen as well as a citizen of the Republic of South Africa. Certified copies of his passports of these countries and various visa stamps appear at pages 52 to 57 of the court record. Tanzanian citizens having citizenship rights do not require visas to enter their own country. To cap it, we have on record the appellant's own affidavit regarding a residence permit to reside in Tanzania. Based on these findings, the respondent submits that this initial criteria of proving Tanzanian nationality or citizenship by birth by being born in Tanzania has not been met by the applicant, as the passports clearly reflect the words nationality, South African, place of birth, South Africa. Honorable judges, the second factor is that the burden of proof that the applicant is Tanzanian rests on the applicant, and it is the respondent's contention that the applicant has totally failed to execute this burden. It is the respondent's contention that the applicant has totally failed to execute this burden, rather than producing unequivocal evidence that he's indeed a Tanzanian. The applicant provided conflicting, contradictory information on his birth and nationality as follows. During his trial, he produced 2 witnesses, none of which were his relatives, all in their early 20s, one a taxi driver, another a casual friend. Both gave testimony that they purported that they saw him with some sort of document. During the trial, he said he used a Tanzanian passport to enter the country, but this passport was not tendered in court. Further, he forgot to bring important documents to court to submit to support his claim that he's indeed a Tanzanian. He gave conflicting testimonies over who his mother is. At page 39, he said his mother is Anastasia Maitland, who adopted him. At page 39 again, he stated he did not know his parental mother. At page 29, this is of the judgment, he said he believes his mother is a Tanzanian. During proceedings, he proceeded to call his advocate a liar in court. The same advocate defending him in court, the same advocate who certified the copies of his passports. In court, he stated he never met his biological mother, he never saw his biological father. He informed the court that his grandfather is Godwin Rogomale, father of his mother. However, the witness that he called informed the Honorable Court that he never knew any Godwin Rogomale. Honorable judges, the applicant's witnesses were merely a taxi driver and a friend. They could not testify as to his birth or his nationality. This further begs the question, why did he not produce his Tanzanian family to testify on his behalf? He was facing various serious offenses. The burden of proof rested solely on him, and he provided very young witnesses who were not useful. He failed to testify as to his nationality. Honorable judges, during his appeal at the High Court in Criminal Appeal number 9 of 2011, the High Court judge was attuned to the applicant's right to a fair trial and agreed for the applicant to file additional grounds, and also agreed for the applicant to file additional evidence. He wanted to tender and to produce documents before the court that he indeed had entered the country legally and that he was a Tanzanian. Rather than produce the Tanzanian passport he made reference to during the trial, he produced a copy of a temporary emergency travel document. Where was his Tanzanian passport, which he claimed to have? The court went as far as to assist him to ascertain the validity of this travel document and called the head of immigration as a witness to assist the applicant to discharge his burden of proof. However, the court noted that possession of the emergency travel document is not considered evidence of a national status. Another interesting factor that was born out of this emergency travel document, and this can be seen at page 18 of the High Court judgment, is that it reflected the names Robert John Penessis, being John Robert Rubenstein, also being John Maitland. The High Court found that the applicant presented his application for an emergency travel document. He attached photographs, certified copy of a birth certificate of his mother. The court discussed that his mother was Anastasia John Nicol Penessis, born on the 8th of August 1941 in Bukoba, and the mother and father of Anastasia are shown to be of Greek nationality. Therefore, his mother was born of people not citizens of the United Republic of Tanzania, and he, therefore, cannot be a Tanzanian, even if his mother was born in Tanzania. This led the judge to question the applicant's birth certificate, and at page 20 of the judgment, I quote, the judge stated, "It is unfortunate that his birth certificate shows both his parents are Tanzanian citizens, but in light of PW2, the information that the birth certificate is questionable." Honorable judges, it came to light that the birth certificate of the applicant was indeed forged, and this was followed up by RITA. Their investigations into the matter at that point in time revealed that the applicant was facing deportation proceedings, and in light of those circumstances, they did not pursue criminal action against the applicant. The High Court also pondered if this birth certificate reflecting that he was a Tanzanian had always been in his possession, how come it was not tendered during the trial court? Honorable judges, it can be seen how despite efforts by the High Court to assist the applicant in defending his case and accessing him the right to a free trial and to discharge the onus placed on him to prove that he is indeed a Tanzanian citizen, the applicant continued to raise doubt over his status. This was also joined hands with by the Court of Appeal. In its judgment, at page 7, the Court of Appeal stated that regardless of possession of a birth certificate, a certificate of birth alone does not confer one with citizenship. At page 8 of the judgment, the Court of Appeal held there is on record undisputed evidence showing that the applicant is a British citizen as well as a citizen of the Republic of South Africa. Further, at page 8 of the Court of Appeal judgment, they held the passport copies have various visa stamps to enter Tanzania, and Tanzanian citizens having citizenship rights do not require visas to enter their own country. The Court of Appeal also stated at page 8, it is on record that the applicant's own affidavit regarding a residential permit of Tanzania as part of this application, he stated under oath that he has good intention of processing his Tanzanian citizenship if the law and authorities allow. This observation was made by the Court of Appeal in its judgment. Therefore, it points to the fact that the applicant did not have Tanzanian citizenship. He had good intention of processing such Tanzanian citizenship. The Court of Appeal also considered at page 8 of its judgment that the burden of proof was on the appellant, and as per Section 30 of the Immigration Act, it subsequently held at page 9 of its judgment that, in view of our discourse above, we are satisfied that the appellant miserably failed to discharge that burden. Honorable judges, in light of the fact that the applicant has failed to meet the principles, requirements of discharging the burden of proof that he was born in Tanzania, the respondent submits, as it has always done so, that the applicant is not a Tanzanian national. Honorable judges, the final principle or matter that we should bear in mind when we consider his nationality is that the laws of Tanzania do not permit dual citizenship once one has attained the age of 18 years. Therefore, regardless of any claim or explanation given by the applicant, the mere fact that he possesses passports of other countries claiming him to be their national and citizen while he's above 18 years of age nullifies any contention that the applicant is a citizen of the United Republic of Tanzania. It is the respondent's position that, as reflected in the certified copies of the applicant's passport, the applicant is a South African national who was born in the Republic of South Africa. Further, it should be noted that the person Robert John Penessis first came into existence with the production of the forged birth certificate. He did not exist prior to this document being forged. There is also no dispute that the links have been made, and John Robert Maitland is also John Robert Rubinstein, who created the person Robert John Penessis. As they are all one and the same, this individual, the applicant, is the owner of the South African and British passport, which reflect John Robert Rubinstein as a South African national. The applicant, honorable judges, is not a Tanzanian. Honorable judges, I pray to submit on the allegations of the alleged arrest and detention of the applicant. This has been largely canvassed by my colleague when she discussed the preliminary issues, but basically the applicant was convicted and sentenced for a lawful offense provided by the statutes of the United Republic. He was found guilty for the offense of unlawfully entering and presence in Tanzania, contrary to the Immigration Act. He was sentenced to pay a fine of 80,000 Tanzanian shillings or to face 2 years imprisonment or 10 strokes of the cane in default. He opted to pay for the fine. However, as he was dissatisfied with the judgment, he proceeded to file an appeal at the High Court, and it was during these proceedings that he was charged with contempt of court and sentenced to a 6 months period. Being aggrieved with the decision to uphold his conviction, he further appealed to the Court of Appeal of Tanzania. The Court of Appeal of Tanzania held that though the High Court found him guilty, it was not proper for the High Court to issue a deportation order. Rather, this jurisdiction was the responsibility of the minister, being the Minister of Home Affairs. And this is what followed, Your Lordships. Thereafter, the Minister for Home Affairs issued a deportation order, which is administratively accompanied by a detention order against the applicant. He was detained at Bukoba Central Prison pending his deportation, and this is the status to date. He is not facing any civil case, he's not civil sentence, he's not serving a criminal sentence. The fact of the matter is that the applicant has refused to comply with procedures to deport him. As stated earlier, South African authorities are willing to retain their national, but there are certain procedural aspects which have to be implemented, and the applicant has refused to comply. He continues to state that he's a Tanzanian citizen, a national of Tanzania. So it is based on this premise that we submit that the allegations of the alleged unlawful arrest and detention of the applicant are totally not false. The continued detention of the applicant is a product of his own doing and his own lack of cooperation with authorities. Honorable judges, I pray to close my submission with regard to the merits and to proceed with prayers of the respondent state. As we conclude on the merits, we'd like to state that the state endeavors to guarantee all the rights enshrined in the African Charter on Human and People's Rights. However, all such rights are guaranteed to people who abide by the laws of the land. We pray to conclude on the issues of merit by disputing the allegations, and that they should be duly dismissed for being void of merit. Our prayers with regard to the jurisdiction and admissibility of the application is for the Honourable Court to declare as follows. Firstly, that this Honourable Court is not vested with jurisdiction to adjudicate on the application, that the application has not met the admissibility requirements stipulated under Rule 45 of the Rules of Court. Third, that the application has not met the admissibility requirements stipulated under Rule 46 of the Rules of Court. Fourth, that the application be declared inadmissible and that the application be dismissed with costs. With regard to issues of merit, we ask this Honourable Court to declare that the applicant, also known as Mr. Robert John Penessis, is also known as John Robert Penessis, who is also Robert John Maitland and Robert John Rubenstein. The Honourable Court declared that the applicant is not a citizen of the United Republic of Tanzania, that the applicant is a dual citizen and national of South Africa, as well as Great Britain and Ireland, that the conviction and sentence in criminal case number 35 of 2010 was lawful, that all aspects of the prosecution of criminal case number 35 of 2010, criminal appeal number 9 of 2011, and criminal appeal number 179 of 2011 were conducted lawfully, that the deportation order issued against the applicant is lawful, that the detention order issued against the applicant is lawful, that the detention of the applicant is not aimed at disposing of his property, that the government has and continues to enable him to access health care, that the applicant's family and lawyer have had access to him in prison, that the government of the United Republic of Tanzania has not violated the applicant's right to defend himself, that the United Republic of Tanzania has not violated Article 1 of the African Charter on Human and People's Rights, that the United Republic of Tanzania has not violated the applicant's right to nationality as provided by Article 15.2 of the Universal Declaration of Human Rights of 1948, that the United Republic of Tanzania did not arbitrarily deprive the applicant the right to enter his own country as provided by Article 12.4 of the International Covenant on Civil and Political Rights, that the United Republic of Tanzania has not violated the applicant's right to freedom of movement and residence within the borders of the respondent state as guaranteed by Article 12 of the African Charter on Human and People's Rights, that the United Republic of Tanzania has not violated the applicant's right to liberty and security of persons and freedom from arbitrary arrest and detention as provided by Article 9.1 of the International Covenant on Civil and Political Rights and Article 6 of the African Charter on Human and People's Rights. That the applicant's prayers be dismissed, that the application be dismissed for lack of merit. Honourable judges, I pray to close our submissions. We humbly submit.
Thank you, Counsel of the Respondent. This was the first round of oral submissions, and your interventions conclude this first round. We take a break, short break of 15 minutes, and come back to receive testimonies from both applicants, witnesses, and respondent witnesses. court resume.